Hello, my name is Randall Borden. I'm an attorney in Virginia, and I'm here to talk about when or if custody and visitation orders can be modified by the court. It can be modified when there's a change in circumstances. The problem is, you might think there's a change in circumstances. When you go to court, you have to convince the judge that there has been a change in circumstances. So some obvious change in circumstances would be if the child starts a new school, goes from home into kindergarten or middle school to high school, then that's an obvious change in circumstances, and that's when you can go to court and say that it be in the child's best interest to have a new school district or, more a different education program. There are others where it gets a lot more difficult, and sort of at the other extreme would be if the parent with custody gets a better paying job in a different location. So the parent with custody wants to move, and then the parent without the custody says no. The parent has to stay here in this area or switch custody over to the first parent. You then have a pretty substantial battle in court because the parent who wants to move has to show that the new location, the new home, the new house, the new schools, whatever is there, would be better off for the child than staying where the child is and seeing less of the other parent. So the typical situation is a visitation. The child stays most of the week with one parent, then goes to the other parent every other weekend. They alternate holidays, and both parents live fairly close to each other. So if one parent gets a better paying job and wants to move to a distant location, the parent sometimes makes the argument, all the time makes the argument, that because I'm making more money, the child will be better off. They'll have a better school system or a bigger house or whatever the benefits are that would be at the new location because of the higher salary. That's, first off, very difficult to quantify. Exactly what are the benefits that the child would get at the new location that the child cannot get now? Sometimes the parents will try to argue the schools, the public schools are much different, or the public schools are, one is better than the other. Public school is better than private, or private's better than public. They will bring out the statistics showing how many high school graduates from this school went on to college. The judges are not convinced by that. That is almost an impossible burden to prove, unless there's some special need that the child has to go to some school for medical treatment or something like of that nature, or has to be near a hospital for medical treatment and can go to that school. Those exceptions exist, but unfortunately they're not what mostly gets litigated, not the cases that mostly get litigated in court. Alleging best interest of the child, you really have to have your ducks in a row, and you really have to be able to show this is how the child is going to benefit. And it could be, something as simple as being able to go to some kind of training program or go to a camp or some kind of specialty artistic talent or things like that. And of course, you can always have the situation where one parent becomes worse off, whether drinking problem, drug problem, they get disinterested in the child, they just stop visitation, they just they're just too busy for the child. So that would be a situation where the parent would show they're having trouble communicating with the other parent. The other parent is not having the full visitation. Instead of every other weekend, it's maybe once a month for a few hours, or drops them off at the parent's house and then leaves the kids there all weekend. So that's the kind of thing where you could go from shared legal to full legal. If you have a 50-50 shared custody and one parent is just obviously too busy to make time for the kids, then you would want to go and say, the children are being ignored, neglected, the one parent is constantly not showing up for visitation, children are disappointed, the parent doesn't show up for parent-teacher conferences, so that's the kind of thing that you want to have some hard, tangible, like the records, meetings at the school where you were the only one who attended, and the emails from the parent that I can't make it this weekend, maybe next weekend, and you could, the child understandably disappointed. That's the kind of situation where, as always, if there is something major, one parent gets into a drunk driving accident, again, you've got something solid and tangible. You've got the police report, the pictures of the accident, the conviction. The parent shouldn't have visitation, shouldn't be driving at a minimum. And if this is something that's occurred frequently, then maybe only supervised visitation. If there is something that would endanger the child, classic case, leaving the child alone in the house, the parent went out and had a good time. So clearly that would be a visitation to switch it over into either day visitation only or supervised visitation only, something like that. Obviously domestic violence, you would get a court or protective order, and then that would give you the basis for to modifying a visitation order in another court. So those are the main reasons. I kind of gave you the reasons at each extreme, and then the reasons that are in the middle of the road. Unfortunately, a lot of times the parents think they have an airtight case. They're going to move to a better neighborhood, a better house, better schools, and it's obvious in the best interest of the child, but the courts don't always see it that way. So hope that provided some help and information, and but no matter what, you have to have tangible proof. You have to have the records of the arrest record of the parent in the drunk driving. You have to have the missed meetings at the school, that kind of thing. You have to have some good evidence to show that the one parent is becoming a bad parent. Thank you. I appreciate it. I hope this was helpful. Randall Borden. Thank you.